So the Australian Competition Tribunal made a decision to declare access to the Port of Newcastle shipping channel services. In the immediate term, that means that users of that service now have the ability to seek an access determination from the ACCC, which is effectively an ability to challenge the terms, including pricing, on which that service is being made available. But the significance of the decision extends well beyond that, because the decision turned on the legal interpretation of one of the declaration criteria for regulation under the National Access Regime. In particular, Criterion A, which is about whether access or increased access would promote a material increase in competition in another market. When the Acting Treasurer initially refused to declare access to the Newcastle shipping channel services, that was done on the basis that Criterion A should be interpreted as comparing access on reasonable terms and conditions following declaration with the status quo. And because the differences in cost that were caused by the price increases following privatisation were not considered significant enough to change the investment decisions in coal or other markets, it was determined there wasn't a sufficient promotion of competition, and so declaration was initially refused. Whereas the Competition Tribunal has importantly determined that what you compare is the entitlements to or rights of access that will exist following declaration with a hypothetical world in which no access is being provided, even though in this case access was actually being provided to the channel. And for monopoly infrastructure, where the real issue is alleged to be monopoly pricing, that significantly increases the prospects of services of this type being regulated under the National Access Regime. And that has implications for how monopoly infrastructure service providers price these services, and then for governments and bidders becomes an issue they'll have to consider carefully about the future prospects of access regulation, what that means for future pricing, and that will be an issue for future privatisation transactions.
So in November 2015, the federal government released its responses to the Harper Review and to the Productivity Commission inquiry in response to the National Access Regime. And one of the recommendations that they've accepted from the Productivity Commission is amendments to Criterion A, which is the criterion that John was just discussing. What they're likely to enact is changing it to become a comparison of likely future access under access regulation on reasonable terms against what's essentially the status quo. So no declared access, but taking into account the access that people might have at the moment. That's clearly different from what happened in the Newcastle shipping channel decision, and it's clearly different from what the tribunal thinks the current state of the law is. So if we see these legislative changes, it means there will be amendments to the law and it might change the future of the Newcastle shipping channel. So in terms of things sitting on the horizon that might change access regulation in Australia, the most obvious is the federal election that's happening in July. So while the federal opposition have released some responses about what they will do about the Harper Review recommendations, they haven't said anything about the National Access Regime so far, which means that if we have a change of government, we don't know what's going to happen. In terms of what the government that we have at the moment has said is going to happen, there have been two other recommendations that they've made to the National Access Regime criteria. The first relates to the public interest criteria. So what they've said is they want to change it from a test of access not being contrary to the public interest to access promoting the public interest. And you can tell from the way that's worded that that's clearly an increase in that threshold. The second relates to the uneconomic to duplicate criteria. So that test at the moment is the private profitability test that was set out by the High Court in the Pilbara rail access disputes. And they want to change that test to be a test about whether total foreseeable demand could be met by one or more facilities at least cost. And that's going to reduce that the threshold for that criteria and make it easier for people seeking access to satisfy.
And in addition to that, the ACCC has been on a very public push to try and increase the scope of access regulation. In particular, the chairperson, Rod Sims, has been very vocal about his perception that the privatisation of assets without appropriate regulation in place is damaging competition and investment in some of the dependent markets. And it'll be really interesting to see how they respond to the Competition Tribunal decision, which in effect addresses some of the shortcomings that Rod Sims has been talking about. In addition to that, those same comments are also being raised in the East Coast Gas Inquiry report that the ACCC recently published, where the proposal was to substantially change the way the coverage criteria for pipelines work, so that a pipeline could be covered and then regulated if the pipeline had substantial market power that was likely to continue in the medium term, and that coverage will or is likely to promote the achievement of the national gas objective. And based on the report and the number of pipelines which are said in that report to have market power, you would anticipate if the test was changed in that way, the number of pipelines which are regulated in Australia would increase dramatically. And that will of course create a really interesting policy question about why it is that gas pipelines should be regulated in one way when they're not talking about changing the national access regime criteria in the same way.